I sent a letter to the defense lawyer letting him know that we have a medical expert who's going to be testifying at your trial. You know what the defense attorney does? He turns around, he says, "Screw that! There's no way in hell this guy is testifying. Take these papers back right now." Can he do that? Can he actually do that and throw it back in our faces? You want to know the answer? Come and join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so here's the scenario. You went ahead and sued your doctor, claiming that your doctor was careless and violated the basic standards of medical care. You're claiming that the doctor's carelessness caused you harm and injury, and that your injuries are significant and or permanent. Now, your doctor denies all of your allegations. And besides, he turns around and says, "Hey, listen, why are you suing me? You, the patient, caused your own injuries." Can you imagine that? The doctor actually accuses you, the patient, of causing your own injuries. So now, during the course of the lawsuit, the defense refuses to accept responsibility for your injuries. They refuse to accept that anything they did wrong caused you harm and injury, and in addition, they refuse to acknowledge and accept that your injuries are significant or permanent. Okay, so now we're getting closer to trial. As we get closer to trial, we are obligated to notify our opponent of the various medical experts we have hired to come into court and testify. Now, you should know something really interesting. In medical malpractice cases, we do not tell the defense the names of our experts. We are required to disclose where they went to school, where they did their training, what hospitals they are affiliated with, and what states they are licensed to practice medicine in. And we have to provide that information to the defense. The defense reads this stuff, he turns around, he says, "This is garbage. I am not accepting this." He will make a copy of it before he sends it back with a letter that says, "Hey, counselor, I am not accepting this for the following reasons." And now he makes up some cockamamie reason about why he doesn't think it's valid. Now, can he do that? The answer is yes, he can. Because if he doesn't think that we followed the specific rules, notifying him and putting him on notice that we've hired a particular medical expert and what our expert is going to be talking about, then he does have a right to go ahead and send it back to us. Does the defense attorney really have to send back our papers notifying him which experts we're calling at trial? The answer is, in New York, he does. That's one of the only ways that we know that he's rejecting our responses. He's saying, "Listen, your response is not appropriate. You did not comply with the rules and regulations in this state about expert witness information. You did not include X, Y, and Z, or you did not serve this on us quickly enough or soon enough or within the appropriate time frame. And because of that, I am now rejecting this." Now, what does that mean for the purposes of trial? Does that mean that my expert won't be able to testify? No, here's what it does mean. It means if the defense attorney is correct, and I go ahead at trial and put this witness up on the witness stand, now the defense lawyer is going to object and say, "Judge, I object to this witness testifying for the following reasons," and that the response that we provided whenever we did was inappropriate, and because of that, he should not allow this expert to testify. It will now be up to the judge to listen to that argument, as well as my explanation about whether or not to allow this witness to testify. Here's the thing. I don't want the judge to make that decision at the time of trial. Why not? Because if the judge turns around and agrees with my opponent, now I don't have a medical expert to testify. Now I'm screwed. And because of that, we could have our case thrown out and dismissed if I don't have another expert to come in and testify. In these medical malpractice cases, we are actually required to have a medical expert testify on your behalf to support your claim that your doctor was careless, causing you significant harm and injury. So it is critically important that we have an expert testify, at least one. If the defense attorney is actually correct that we did not take the proper steps to provide the appropriate information, now we are going to be at a significant disadvantage, and there's going to be a big question mark at the time of trial about whether or not our expert can testify. So what can I do to eliminate this problem or this potential problem? Well, number one, when we prepare the information to send to the defense about which experts we are going to produce, prepare it as properly as possible, as completely as possible. When the defense returns my papers that I've sent to him, he will likely point out the deficiencies that he believes exist. So what can I do? I can go ahead and fix that problem by addressing those deficiencies, by now providing him with certain information. If I feel I'm on strong ground, though, and don't have to provide that information, then guess what? I'll reply back and say, "Listen, I'm sorry, but I don't have to provide that information. Here's the reason, here's the case law why I don't have to provide it." At that point, I'm on better ground, knowing that we're going to go to trial. The expert will get up to testify, and now the defense will make the same exact argument, but at least I will be on stronger ground, and now I can explain to the judge why we are slightly more likely right than wrong that what we are claiming is true. So why do I share this great information with you? I share it with you because this comes up often in these medical malpractice cases. And now, if you happen to be going through this process, and now your attorney tells you, hey, listen, we just got notified from the defense that they are rejecting the papers we sent to the defense about which experts we're calling, and now here's what we have to do about it. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.